Let me pull up. Here we go. Okay. Hello and welcome to IPO. My parent is blocking the camera. He's just going to have to join me. My name is Jennifer and this is Yoshi. Idea to IPO has been holding tech startup events in Silicon Valley for many, many years. We organize venture capital panels, legal workshops, networking events, and more. These days, we are entirely online. We hold an event nearly every day of the week. Please check out our schedule at ideatoipo.com. Our featured speaker today is Dr. Stephen Colby. He is one of the top intellectual property attorneys in Silicon Valley, and he's passionate about helping entrepreneurs succeed. Ladies and gentlemen, Dr. Stephen Colby. Dr. Colby, please take it away.
Thank you very much, Jennifer, and thank you, Yoshi. It was good to see you again. I hope she's feeding you the best sunflower seeds out there. So I'm Stephen Colby. I'm a partner at the law firm of Ramon Law, which is a semi-virtual law firm distributed throughout the world. We have about 45 offices, and we are semi-virtual in that most of the attorneys work from home. Our offices tend to be mostly conference rooms and support staff and a few attorneys who do work in the office. So I'm actually in California today. I'm traveling a little bit and I'm enjoying the beautiful, cool weather of San Francisco. So it's 9 o'clock at my time. And I see we have people all over the world as usual. I want to thank Idea to IPO and Rob for hosting this seminar. They're a real pleasure and he always does a fantastic job. So today I'm going to talk about intellectual property, and I want to give a little disclaimer first. Listening to this seminar doesn't create a attorney-client relationship between us. That requires some paperwork and an agreement. But I'm going to be speaking for about an hour, and then I will have about half an hour for questions that I will answer. If you have questions, please put them in the Q&A text. Enter them as questions in the Q&A, and I will go through that first after I finish my presentation. Let me just make sure I can see that. All right, so I will go through the Q&A questions first and answer them as many of them as I can. I will also give my email address and my link, or email address is there. So anybody who's listening is welcome to go ahead and give me, drop me an email and ask further questions if they'd like. All right, well, let's get started. The first question is, right, why would we do this, okay? And I'm talking to you as typically clients I work with are early stage startups. You know, sometimes they get big, but actually the biggest client that started as an early stage startup and then we worked on their first patents, and I still as a client, is Facebook, which is now pretty big. So they get big, right? But they usually start with me early stage. And most of the people listening to my webinars are usually looking at starting something. And I'm expecting you to be a startup that is planning to take investment and grow quickly based on the investment. The strategies and things I'm going to talk about are a little bit different for situations where it's a, for instance, a family business. If it's a flower shop, there's a few things in here that are applicable, but I'm assuming that what you're interested in is starting a Silicon Valley type startup that's going to grow real fast and you're going to have a wonderful exit, okay? So the question right in front of you is, why would a cash limited startup put thousands of dollars into an IP portfolio? And I hear the wrong answer a lot. So I go to pitch events all the time and I hear founders talking to investors, and investors will ask them, what about the competition? And the founder will say, oh, we have a provisional patent application we filed, so we don't have to worry about the competition. That's the wrong answer. For an early stage startup, an IP portfolio isn't for defense, right? It's for valuation, right? It's to make the company more valuable. So I have a client that just I started with about a year and a half ago, and they just had their IP portfolio valued by a professional service, and it came in at the low 9 figures, right? I mean, it's a really big number, and that really is helping with their financial fundraising. They're doing a round, and they were going to do it at a $40 million valuation, and now they're, because they got a IP valuation that's better than that, they're doing it at a $60 million valuation, right? So the goal of a startup, of doing IP for a startup, is to get your value higher. Every time you raise money, you have to pay equity for that money. And equity is one way, it only goes out, okay, it never comes back. So you want to get the best price for your equity, the most money for your equity. And if you can have a more valuable company, you can get a better price. And then, of course, there's the end, there's the exit. My goal is that when I've finished with a company and they're about to exit and they're being bought by somebody, the IP portfolio that I've prepared for them pays for itself many, many times over. So the reward for that, it can add a huge amount of value to a company on an exit, and that means a lot of money in the founder's pockets, okay? I have seen a couple of cases where there was more than one startup that was being considered to be bought by an acquirer, and they chose the company with a better patent portfolio. So one company had a multi-$100 million exit, $400 million exit, and the other company went under, right? And that difference was in part, well, the company that got bought had a better CEO, but in part it was because it had a better earlier IP portfolio. It beat them, and it had a really thorough IP portfolio. So that's just one example. The reason that IP isn't really a defensive tool for early stage startups is because litigation in IP is really expensive. So if you're a startup and all of a sudden you find yourself in patent fights, that means you've probably become a patent enforcement company, right? If you're on the offensive, right? And that means that you're going to spend millions of dollars on IP litigation and all your time on IP litigation. And you've become a patent enforcement company, no longer a company planning to do whatever else you were doing. And that's usually not as favorable an exit for the founders and the investors as selling the company and with some great assets and a great IP portfolio in it, all right? So that's why you're gonna do IP of some sort, right? And because it will increase the value. So that's the first thing to remember from this seminar, is the reason for IP is improving the valuation of your business, of your company, right? So what do we keep talking about IP, or intellectual property. So what can you get? Well, you can get copyrights, trademarks, trade secrets, and patents. And in this slide, I'm going to talk a little bit about each of these. I personally am a patent attorney. That means I have a technical background. I have a PhD in analytical chemistry, which is a type of chemical engineering. And I do lots of software, probably 70 or 80% of the work I do is software related. But I work on everything from RFID to lasers to medical devices to medical materials sometimes. In my practice, I don't do pharmaceuticals, right? Drugs are for something else, right? But in Ramon has about 20 patent attorneys, and so we pretty much cover everything that there is, right? So back to the slide here. Copyright. Copyright is something that you would get on a logo or a picture or your website or a written document. Okay, it protects the actual rendering of some creative content, whether it's a movie or a video that's posted up to YouTube, or instructional video. Software code can be copyrighted. Every time somebody writes software, there should be a copyright string somewhere embedded in the code, right? And when the software interface pops up in front of the user, the introduction screen should say copyright so-and-so with a date on it, right? So that's a copyright. It doesn't cover the general idea, right? So if I'm writing a book, right, about two people meeting and falling in love, a copyright doesn't cover the plot. The copyright covers the actual writing of the words, pretty much, right? Okay, so that's a copyright. So for startups, the things that you're most likely to copyright are software, web interfaces, right? Marketing material, promotional material, and copyright occurs automatically, right? Once a piece of creative material is created, there's a copyright that applies to that, right? You can register your copyright with the Library of Congress, and that's pretty easy. There's a nice web interface, and it costs about $25. You can register your copyright, and the reason you would do that is then you can enforce it. In order to enforce copyright rights, you have to have registered the copyright. So occasionally, if you're a software company, you will take snippets of your code and copyright them, send them into the copyright office, or your UI, your user interface, you'll take a screenshot of that and copyright that. And all your written materials should have little copyright notices on them saying, hey, this is our copyright, right? Trademark, compared to copyright, trademark is intended to represent goods or services, right? So I'm looking right now at a Logitech camera, and it has Logi on it, right? That is a trademark of Logitech, and they use that to identify their goods. And it could be a service, you know, a consulting service can have a trademark. A flower shop can have a trademark. To get federal registration on trademark, you have to do commerce between the states, right? You all know famous trademarks, Harley Davidson, Rolls-Royce, things like that. So a trademark is associated with the goods and services. And when you use something, right, and you sell something, you can put a little TM by it, and that gives you initial common law trademark rights, right? So when you have a website, if you have your product name or a logo that you use to represent the product, right, or the service, put a little TM next to it, right? And that's free, okay? It takes only a few keystrokes, basically, right? You can register your trademark, which gives you official protection. And after you register it, you can use the little circle R, all right? Registration of trademarks is relatively inexpensive, $1,000, $2,000, kind of on that order of magnitude, right? And that gives you, again, rights to enforce. It gives you a registration on, you know, other people searching for trademarks will find yours and see, oh, we should keep away from that, right? Trademarks can add an awful lot of value, right? We all know McDonald's, we all know Coca-Cola. Those are all trademarks that have huge, tremendous value because of their association with a product, right? So if you provide any service or product, you will probably have a way of identifying it. If you have a way of identifying that is not just purely descriptive, you probably have a potential trademark there, right? If it's Joe's car sales, that's a little bit too descriptive, and you're probably not going to get a trademark on that, right? All right, trade secrets can also be very valuable. Trade secrets are anything that has commercial value that you intend to keep secret, right? And trade secrets can also be a really inexpensive way of establishing intellectual property, and a lot of companies fail to do this properly. There's a big difference between a trade secret that's actually documented and a company that has a trade secret and managed by a trade secret program in a company, and a trade secret that says, oh yeah, I guess our marketing list and our prospects and our chemical process for the way we do our secret coding, that's all our trade secrets. But we don't actually, you know, everybody in the company knows about it. We don't do anything to identify those things as trade secrets. We ignore that. You know, our sales guys know about it, and if somebody asks them on the trade show floor, they might say, yeah, well, so and so, right? Okay. Compare that with a company that has a trade secret program, and they have a physical binder with one-page descriptions on 12 different things that they consider to be the most important trade secrets of the company. The sales information, their secret algorithms they use on their servers, their chemical processes, or their marketing strategy. These are all trade secrets, and only a limited amount of people in the company are allowed to receive that information. They initial or sign a document that says, yes, I'm one of the people who are getting this trade secret, and I agree not to send it to anybody else. In an exit interview, they're reminded what the trade secret is. That company has valuable trade secrets because it actually has a program built around them. All right. If there's a fight over trade secrets, the first defense is, oh, that wasn't really a secret. Everybody knew it. The company was loose and free about it, right? A proper trade secret program can produce secrets that actually create value, and actually can create value at the exit of a program, of a company when it gets bought. I have an example of a company that I have worked with over the years that does chemical coatings. They have a nano coating, and it is on the Golden Gate Bridge here in San Francisco, right? It is used in Dubai at the Ferrari Stadium. It's a great coating because it keeps, it protects against UV, and it prevents graffiti. You can't paint on the Golden Gate Bridge. The stuff comes right off, right? How that material is made is kept as a trade secret, right? And that is actually the core value of that business. It's not patented, it's kept as a trade secret. So that's an example of something that, if that company was ever bought or traded, that would be a trade secret that has real value, and it will last for many years, longer than a patent would, right? Okay, final thing we're going to talk about is patents. And most of the rest of my discussion today is going to be patents. Well, frankly, that's the part of the IP that I deal with most, but it is also one that it costs more money than the rest. And so we really have to think strategically about budgeting and how one spends money on patents and how that fits into the overall business, right? It's something you have to put more thought into, right? Okay, so let's talk a little bit about patents. What do we got here? There's lots of different types of patents. There's specific patents on plants, for example, and on semiconductor masks and things like that. But the most common ones that you're likely to see are called provisional patent applications, okay? Non-provisional patent applications and design applications and patents, right? A provisional patent application doesn't turn into anything, right? It's just an application, it's a placeholder, and it only lasts for 1 year, right? A non-provisional patent application will hopefully issue as a US patent, right? That becomes a patent, right? It's called a utility patent, right? A design application becomes a design patent, right? So the provisional application is really useful for early stage startups. It can serve basically as a placeholder. It gets you what I call a stake in the ground. It allows you to say, hey, we've got this cool idea. We're going to do a quick and dirty write-up of it and get it on file with the patent office for relatively small amount of money. And in a year, we'll have to file a non-provisional application within a year that will then get examined and eventually turn into hopefully into a US patent or a family of US patents, right? There's a bunch of reasons why provisionals are really good. They're quick and easy and inexpensive. A provisional application can be inexpensive because an attorney doesn't have to put a lot of time into it. In other words, I can take a document from some founders and from some inventors and give them some advice on it. I can get a paper that's about to go into a journal to be published, or I can take a requirement specification for software. I can put a cover sheet on that and file it as a provisional application. So it's quick and easy, and I don't need to spend too much time on it. So it's inexpensive. What it gives you then is the value of it is directly proportional to how much content, how much stuff you've actually got in it, right? So you could have a provisional application that's 3 pages and is very thin and doesn't really give you much, right? Or you can have a provisional application where somebody's really put in hours. It's a 60-page document and details all kinds of great stuff. And what tends to happen, the problems with provisionals is people tend to do provisional applications that are really thin, that don't have a lot of meat to them. And then a year later, when it's time to write the non-provisional application, you say, oh, we didn't talk about this, and we didn't talk about this, and we didn't talk about this. You know, it's too bad. That stuff's, we don't really have the early filing date for that material. One of the things that the provisional is very commonly used for is if something's about to go public, right? In the United States, if you use something publicly, right, then you have 1 year to file patent applications. And when I say use publicly, I mean, that includes offer it for sale, even if it's a secret sale. If you offer something for sale for money, you know, in a contract, and you make an offer that can be accepted by the other party and create a sales agreement, then that counts, that starts your date, right? Your 1 year date. In the rest of the world, there's no 1 year, right? Once something's used or publicly or offered for sale, then it's no longer patentable. That event is actually prior art against any patent application. So there has to be some, you know, then there has to be some new feature added that then becomes the subject of a patent, right? Okay. So very commonly what will happen is I'll have somebody come to me and they'll say, well, I'm about to give this big presentation at a conference, and I don't want my presentation to be used against me as prior art. And they'll give me their entire slide deck, and I'll put a cover sheet on it and file that as a provisional patent application. And that means that the filing occurs a few days before the actual presentation, and they've covered themselves, okay? But of course, that slide deck probably doesn't include all the fancy details of the technology, right? It's not really enough to make a full patent application. And so it turns out that while we've protected that presentation from becoming interfering with the patent rights, we haven't filed a provisional application that's really got enough meat to it to make a future patent, right? So those are the advantages and disadvantages of provisional applications, right? You can do a bunch of them in your first year. You could file one when you're just about to start up, and as you have new ideas, you take that document, you add a few more pages to it, and you file it again. And at the end of the year of the first one, and the anniversary of the first one, you file a non-provisional application that takes the benefit of all the provisionals you filed, right? And that non-provisional application is then going to go to eventually to an examiner, and it's going pretty fast. We're looking at 2 or 3 years now. It used to be longer. I very often get a first office action within a year. And so it'll be examined. Usually a patent application is rejected the first time, and you then have to pay your attorney to argue why you should have the right to a patent and why the examiner is wrong. And this back and forth process could happen several times. It could last for years. It could go to appeal, it could go to court. It could be really expensive, but hopefully around the second or third time, you've either narrowed what you're claiming, or you've persuaded the examiner that they're wrong about what's in the prior art, and you deserve to have a patent, okay? That will issue as a patent. It is good for 20 years from the non-provisional filing date, okay? This means that if you file a provisional application and you wait a year before your non-provisional, you actually get 21 years of lifetime because of the first year of the provision. So you get 21 years. It costs a lot more, and the reason it costs a lot more is the attorney typically needs to do most of the writing, right? And so the non-provisional application will cost a lot of money to get on file, and then in a year or two, you'll start having office actions every 6 months or so, which costs more money to defend against. We'll talk about actual costs later. The third type of patents that I'm actually talk about here is a design application. And design applications can be very useful. One of the favorite ones I was design applications came from a law firm that I used to work for I first started with many years ago, and it's the Polycom speakerphone. And I like using that example because it used to be that I'd be in a conference room talking to inventors and I'd be talking about design applications and there'd be a Polycom phone on the table, right? And the phone I'm referring to is the one that has the nice 3-pointed triangular star shape, right? That cool shape turned out to be really nice. It allowed microphones to be out on the side and had a speaker in the middle, which sent the sound up and gave a good sound. It also looked a lot less bulky than a round phone. Something that was like a flying saucer shape. Didn't look anywhere near as nice as the speakerphone, the Polycom speakerphone. And so that's my favorite example of a design application. You can also have design applications on the shape of a product. Think of an early Apple computer or a Braun toothbrush. Those are types of things. Tire treads are commonly subject to design applications. I interviewed somebody a year or so ago who had done almost nothing but design applications, and they worked for Nike, right? So every version of every shoe is a design patent, right? The design patent, again, it's meant to cover the ornamental part of the product, not the functionality, right? So it's always a shoe and you put it on your foot, but the cool little swoosh symbols, which are trademarks, and the way they're put on the shoe and the stitching on the shoe, that can all be subject of design patents, all right? Okay. When you get a patent, all right, will you rule the world? No. Patents are nationally based. In other words, a US patent is good in the US and doesn't matter in Canada. If you want to get patents outside the US, there's all kinds of procedures for doing so, right? You won't get a patent everywhere. That is prohibitively expensive. The only companies that do something like that are pharmaceutical companies, right? Where even the Philippines matters, right? Sorry, Philippines, but even small countries matter. So what you end up doing is filing your patent applications, and at the end of the first year from the first filing, you have an option for something called a PCT application, and that stands for Patent Cooperation Treaty, right? And it's basically an option that gives you another 18 to 19 months to decide which countries to go into. It costs, the filing fees are on the order of a few $1,000s, $2,000 to $4,000, depending on the type of company you are. And that gives you that option before going into other countries. Then, eventually, if you want a patent coverage in places like China or Korea or Japan or Europe, then you have to file patent applications in those places. And that can be quite expensive because very often there's translation costs, right? In Europe, the filing fees are very high. They're $5,000 or $6,000 maybe. So you end up trying to push those costs off as long as possible, right? You don't want to incur them, and that's why the PCT can be really a good deal for a startup. You also have to decide where to file, and those things can be, a big function of the business. Where are your customers? Where is your competition? Who do you expect to buy you? If you think that you're going to be acquired by Samsung, right, or Toyota, then you're going to be sure to have patent applications filed in countries that matter to those companies, right? If you think you're going to be acquired by Apple, then well, US, right, and Europe. I have seen applications go into Belgium or the Netherlands because there's huge server farms there, right? Where companies like Apple have or Google have a lot of their servers. If your product is an app, you might be interested in looking at countries where app stores are hosted, right? Okay. That's it. Well, let's see. When do you need to start thinking about your IP? Well, you're now, yesterday, okay? It is a first to file world, right? So and I have seen competitors days apart, right? Like a week, 6 days. So getting things on file early is great. And that with the ability to file provisional applications quickly on ideas, that is great. You know, there's no excuse not to put a provisional together and get something filed fast, right? And that can represent the core ideas, and it gives you that priority date of whatever content is in that provisional application. It gives you the priority date, right? If you file something today, it could be that 6 months from now, somebody else's patent issues that they filed a year ago or 2 years ago, right? And it's been kept secret. So you can't always know what somebody else has filed, because patent applications generally in the US, very often they stay secret. In other parts of the world, they're published. If you file outside the United States, you have to have your patent application published so people can see what you have. Those public, but before they're published, right? Or if they're not published, before they issue, that's unknown. People can't search on that. So you never know what's coming up, what your competitors have already filed. So get worried about it and get something on file, because you want to be the one who did this first, right? Okay. Moving on. Now, if you're an early stage company, you probably have a budget, right? I mean, or a limited budget. You're not infinite. I have had clients who were really, really wealthy, but most of the time that's not the case. So how much does this all cost, right? Next slide. All right. This is really ballpark stuff, okay? I just wanted to give you in this slide some impression of about like what does getting a patent cost, okay? And it depends a lot on the technology, right? I've written patents that are as short as 20 pages, and I've written patents that are near 100 pages, right? And it takes me about an hour per page to get something on file, right? So I've spent 20 attorneys hours preparing one of those applications and 100 attorney hours preparing. So there's huge range in the actual cost, right? You can buy a book at Amazon called Patent Pending in 24 Hours by Nolo Press. It's pretty good and will cost about $40. And you can go and do your own provisional application, right? I don't advise that, because getting at least a little bit of help from an attorney can help you avoid mistakes that are serious, that can kill your whole project, right? So when I have a new company come in, I usually sit down with them and say, okay, if we're gonna do provisionals, we all set a budget. And the 2,500 I put down here is a typical budget for a provisional application. And what that means is I'm gonna sit down with the inventor for an hour and we're gonna discuss the invention. I'm gonna give them a set of claims, right? That hopefully someday will be part of a non-provisional patent application, right? Claims are the part of a patent that say what the inventor thinks is really theirs, what's new, right? Then I'll give them an outline and maybe some drawings. We'll get some drawings generated. I'll send the client off and they will go and do writing, right? And you see the part here that it's the client that's doing the work, not the patent attorney. They'll come back to me and I'll give them a draft. I have a couple of drafts to review today that I'm gonna look at. We do that I may make some suggestions, they may make some changes, we go back and forth, we get it on file with the US Patent Office, and that should be all doable easily within $2,500 budget, okay? Some clients don't want as much as my time and we do it for less money, but 2,500 is pretty standard, right? The non-provisional application generally has to be really rewritten by a patent attorney. So budgets there depend again on how thorough and how valuable the application is, how much actual words on the page are there, right? A typical budget for the first patent application is about $18,000 to get it on file, right, with the patent office. And you'll notice here on the slide, there's first application and then there's also family members. So patents can be related to each other. You can have one application that can have daughters, right? And that one can have granddaughters and so on. So it's pretty common for a company to start off with a few provisionals in their first year. And then in their second year, they might file 1 or 2 non-provisional applications. But those applications will be related. So they'll have big chunks of material that can be reused, right? A related daughter application could be the same specification with a different set of claims, or it could be what's called a continuation in part with another 5 pages of disclosure of new invention, right? Of course, the new invention gets a later filing date than the original material, but those are all related parts, members of a family of patent applications, right? So once you start dealing with a larger portfolio, then the cost really does can drop quite a bit. And I've looked at some of my clients that when we have 20 or 30 patents and look back at what we charged for the original filings, and it starts to average between like $9,000 to $12,000, right? To get for each per patent application to get it on file, right? That's the part of the budget that is really can be controlled, right? I can sit down with a company and they can say, well, we only have 15,000, all right? And I say, okay, you're going to get this much, right? You'll have less meat to your patent application. Once it's on file, in a few percent, 5% of cases, they get allowed right away. The first office action is allowance, right? Which probably means you didn't ask for enough, okay? So then there's only an issue fee and some final costs from the patent office, there's another $1,000 or so, and you have your patent. But most of the time, the patent application is rejected in the first office action, and the claims either have to be narrowed or amended, or the patent attorney has to write a document explaining to the patent examiner why they're wrong, why the client is likely to get a patent, has the right to a patent. A typical office action, $4,000 to $6,000, maybe $5,000 on average. It really depends. It's an hourly thing. It depends again on how many arguments there are to make, how many claims there are. Sometimes the examiner's clearly wrong on some point, and it can be done just for a few $1,000s. But we don't know how many times that will have to be done. It can happen that you go back and forth with the examiner, more than 3 or 4 times. And then there's an appeal process, which has a whole another set of fees and charges associated with it, and a big appeal brief. So the cost can go up. I put a number here of $30,000 of getting the patent out. Again, that varies from under 20 to over 50, depending on the patent application. But this is something that you can budget for, and this is money that you're going to spend over a number of years. This is 2 to 4 years time where you might spend that amount of money to get the first issued patent, right? And that's it. When a startup comes to me and they say, how much should I budget for patents in our first year? I usually give them a number of $35,000 to $50,000. And that's a number that it really depends a lot on the company. Maybe they're only going to do 1 patent application, and they're really, I have clients who are in the fashion industry who don't do, they do trademarks, right? And other stuff, they don't do patents. It could be a company that's very tech dependent, and the value of the company is really in the technology. So patents are going to be really important. So they might have a bigger budget. But that number 35 to 50,000 for a quote unquote Silicon Valley tech startup is a number that will make your early investors nod. Okay, you've got some money allocated to it, and that sounds about right for your first year. And of course, depending on the fundraising and on the success of the business, follow-on years, the patent budget could vary quite a bit, right? I have clients that spend hundreds of thousands a year on IP. All right. Okay, next thing that's important, let's talk about ownership, okay? This is important subject for a couple of reasons. The first is you need to make sure you own your IP. I have seen companies that are several years old that have had spent $10 million, realize they have an IP ownership issue, and the company dies, right? Everybody's hard work, 3 years of the life of 40 people is just down the drain, right? And the investors are not happy, right? The ownership of an invention initially vests in the inventors. And this is true of copyright too, okay? You have to have agreements in place that formally transfer the ownership from the inventors to the company, okay? So this is a big take-home point right here. You have to have agreements in place that formally transfer the ownership from the inventors to the companies, okay? And that includes the founders. The original founding agreements, agreements between founders should have an IP clause in it, right? The founders should assign their inventions over to the company. The patent office has a recording system, just like when you buy and sell a house in most countries. There's a process where you record the sale. So you can go to the patent office and see all the transactions for any issued patent, who the initial inventors were, who they have assigned it to, they've transferred it to. So this is in the US, right? And I'm a California attorney, right? In other countries, things are a little bit different, right? So in some countries in Europe, there's a presumption that if it's an employee of a company, that the rights go to the company, right? And that's only a presumption, right? It can be different. And there's a big argument, was the invention in the scope of the company or not? And you would have to talk to a Spanish, if it's in Spain, you'd have to talk to a Spanish attorney about this issue, a Spanish patent attorney, right? So the important thing is make sure there's everybody's employment agreement, every contractor there should be a clause in it that says they're going to assign the IP rights. Let me talk a little bit on an aside here. I have a lot of clients that use Upwork or other gig working, for helping develop software. There is a box to be clicked in the options when you set up a job that you're going to post there, that there's a checkbox that relates to IP, and you have to check that box. If you don't check that box, you don't necessarily get the intellectual property rights to what's being generated. And I've seen people make that mistake. For instance, finding a company logo. Upwork is great. You can put out to 10 people for $50 a piece and get 500 fantastic logos back from them, right? And then you choose one, you make that your company logo. Well, if you didn't check that box, they actually might still retain the copyright on your logo, right? And you have a big problem. A few years later, they come to you and say, we noticed this is being used in the Olympic ads that you are now spending millions of dollars on. Well, we want our copy. So be really careful with this. One example I like to give is, you're all probably familiar with Adobe Forms, right? With PDF forms, right? And that's a really cool use of PDF documents. That was invented by a sales guy, right? So everybody in the company should have in their employment agreement a clause that says that inventions they make that are in the business of the company should be assigned to the company. Now, in the United States, what you can put there is really dependent on what state the employee is working in. And in today's world where everybody's virtual, I normally am in Nevada, right? It makes a big difference. California's laws regarding what a company can capture from an employee is different than Florida's, right? California is much more employee friendly, right? In California, you couldn't say any invention that my employee makes is going to be the company property. And in your cafeteria, the cook invents, you're a aircraft company, and in your cafeteria, the cook invents a new type of ladle for doing soup, right? You don't get that, right? If it's not in the space of the business, it's hard in California to capture that for the company. In Florida, it's different, right? And if you have an employee in Florida, you need to talk to a Florida attorney, not me, right? About how, what you can actually say in that employment agreement. This is part of the employment law issues, right? So, and if you have employees that travel around who are, part year in Canada and part year in the US, you've got to be aware of that, right? Next thing is, so employer IP, you also want to make sure that you don't bring other people's IP into your company, right? So if you have a software engineer and he says, oh, I solved that problem 3 years ago before I started working here, and I still have all that code, so I'm just going to grab it and use it, right? That's a big mistake, right? There's a copyright violation, maybe trade secret issues. This is a way to get sued, okay? And so you need to be very careful that employees are aware that they can't take materials that are owned by other entities, right? And use it in your code or in your software, in your products, right? And this also goes for open source. If you use open source materials, you need to have an attorney review the open source agreements. Some open source agreements require that anything they're used in also be made open source. Okay, and so our former president ran into this issue last year. He tried to release a new messaging service, and they used open source software that required that their entire code be made public, right? And they launched, and within a couple of weeks, they had to pull it off because they were going to violate that agreement, and they were going to get sued. So don't. If you use open source, and your employees need to know that if you use open source materials like software, that an attorney needs to go through the open source agreement, and you really need to understand what's being used, right? And keep in mind the assignment process. You need to make sure that assignments are properly done. If there's an invention, a patent application, right? Your patent attorney should be pushing an assignment on you, saying, hey, you've got to get all your employees to execute this assignment so that the company owns the products, that the company owns the invention, right? I'm going to tell a story here. So my field was chemical instruments, right? And there was a professor, right? Meaning an employee of a large university in the East Coast, and Ivy League university in the East Coast. And he invented a great technique of chemical analysis. And he founded a company on it, and it was a hugely successful company. And he totally ignored the fact that he had an employment agreement with the university, and the university had rights to this. And the university didn't really pay attention, right? And then he made his big mistake. He won the Nobel Prize, right, on this invention. And so all of a sudden the university said, hey, wait a second. That was done here in your lab. We own that product. And he lost pretty much everything, right? The university sued, ownership of the company, the investors were very, very upset, right? Basically all his rights in the company went away, and he lost it all, right? This is what you call making dumb mistake, right? Everybody can make dumb mistakes. Make sure you have ownership of your IP, and it is in my career, it is the #1 killer of companies. Like, oh, so-and-so never signed that document. Yeah, but he's my I'm a godfather of his son, right? Well, that didn't help, okay? People, they get business divorces, and I've seen literally where there's actually a divorce between the founders, like they're married, right? And they get divorced, and somebody hasn't signed an assignment agreement, and that kills everything, okay? All right, sorry to be so negative, but let's talk on good stuff. Strategy. This is an important thing I want you to keep in mind. remember, patents are to increase the value of the company, okay? That means you don't necessarily want to patent what the engineer thinks is really cool. What you want to patent is what the sales and marketing people love. When they go out there and say, hey, we're the only one that has this indispensable feature that you've got to have, come buy our product, right? It's patented. Nobody else has this, right? You want to have a strategy that starts at a high level and says, what is it that's going to make my company a success? What are you telling in your, before when you raise your first money, what are you telling your investors? We're going to be number one because of A, B, and C. These are fantastic new ideas, improvements. You know, it could be a technology, it could be a new way of doing business, whatever you're saying. Those things are your quote unquote silver bullets, right? That are going to make the company a success. And you want IP that covers those features, okay? The process should be product driven, right? Not in necessarily, oh, this invention is really cool, but there's not really a market for it yet, right? It's got to be focused on increasing the valuation by filing intellectual property that covers the things that are going to make your business a success, right? And that makes IP more than a checkbox. I often give clients, when they're doing their later rounds, A and B rounds of fundraising, I'll give them a chart that shows those magic tricks, those I hate using bullets, but the silver bullets that make their company successful, surrounded as bubbles on the slide, surrounded by other bubbles of different color for all the different patent applications with lines drawn all over to make a big spider web, right? I call it a cluster map. And it shows the relationship between the IP that's been filed or maybe even issued at that point, and the things that that are key value drivers for the company, right? And that conveys to an investor in their pitch deck, hey, this IP is really valuable. It's more than just, yeah, we've got 8 pending applications and 3 that's issued. Well, that little string on a slide doesn't really convey the value of the patent portfolio. So that's a slide that I'd like to do for my clients, right? Okay, we talked about this a little bit already. Let me see what else I've got. Okay, people's IP. Okay, this is I get a question a lot from founders, should I read other people's patents? My answer is yes. And that's partly because I come from a science background, right? So I like to quote unquote, read the literature and know what's going on. Now, if you're an employee that works for Intel or Boeing, they don't want you reading other people's patents because it puts them on notice of the patents, and that increases their liability, financial risk, legal risk, okay? But for an early stage startup, I say, yeah, you wanna know what's out there, because in your early days, if you see somebody else's patent, you can engineer around it. And every year I have at least one client who says, we just saw this patent, and it looks an awful like what we're doing. And then I'll look at it and say, yeah, okay, but you don't do that, right? You can avoid this patent by tweaking this or twisting that, or making some changes in your product that doesn't really impact your business, and get around it, right? And also, I like quote unquote reading the literature, because if you read other people's IP, it sometimes will give you ideas, right? So for example, you might look at somebody's patent and go, they're doing this, but they're not doing it quite right. If they had all the ideas that were in my mind, they'd do a much better job. They could do this, boom. And now you have a new invention, an improvement over their patent, a better way of doing it, that's gonna be a great defense against them, right? And maybe it's gonna force them to buy you someday for lots of money and make you really happy, right? So read the literature. The last thing about this is keeping records. So again, as a scientist, I have somewhere in the garage a big stack of lab notebooks for all the years I was in science, right? Keep good records at every meeting you go to, right? have your screen open or your notebook. I have some of the best CEOs I work with, they have bound notebooks, and they're always, every time you sit down with them, they flip the notebook open and they're taking notes about what the discussion, right? These records can be really valuable, even though we're first to file, not necessarily first to invent. And let me give you an example. Let's say this afternoon or tomorrow, you have a meeting about a great new, and you come up with that meeting, a great new feature for your product. We're going to do this. Oh my God, it's a great idea. The 3 or 4 people at the table are like, oh, fantastic. We're going to go and let's send off an email to our patent attorney. But you've also written notes down and say, you know whose idea it was during the meeting. So eventually when you figure out who the inventors are, you have some record, right? And you have a description in your notebook, right? And it turns out that 2 weeks later, before you filed your provisional, you hire a new engineer, okay? And a year and a half after that, that engineer's prior employer sues you for trade secret theft, right? And it turns out that that other company had the same idea, okay? And they are thinking that you hired this person and he told them their trade secrets. Well, it's really fortunate that you've got this great records, right? That could be, if they're in a computer, they could be on an email filing system. They're digitally recorded somewhere. There's a nice history of them. They're good evidence. You can say, no, we had this meeting, this date, 2 weeks before we hired him, and this is the notes from the meeting, and please go away. And that notebook entry has just saved you $250,000 or more, right? So that's the advantage. Keep really good records for all kinds of reasons. Okay. All right. I'm going to try to finish. I have one last slide before finishing up. And this is kind of, I give another webinar just on this subject, right? So I want to kind of review here. The biggest mistake you can make is ownership. Make sure you own your own IP. Okay. The second biggest mistake you can make is ownership. Make sure you don't get IP that belongs to others. Okay, ownership deserves to be there twice because it can nail you. All right, this is one of those things that founders should lose sleep over. Right? Okay, waiting, definitely number 3. The idea of okay, we don't have the product quite right, so we're not going to talk to the patent attorney yet. You know, you should be filing provisionals, and every different version of the product, every new design should have something filed about it right away. Okay, even it can be that you in the first year your company changes a lot, and then you'll say, well, it's a good thing we did provisional applications instead of spending 20 grand on a non-provisional, right? Because that idea is not going to work. We now have a new idea, right? And we still have money left to do another provisional, and we're going to protect that. Right? So don't wait. File as soon as possible. I'm very often, as an IP attorney, I see founders before they're even talking to corporate attorneys, right? Before they even talk to investors, because they want to protect what they have before they go out and talk about it, right? Okay. Have a strategy. Remember that what the IP is for. It is for the valuation of your company, okay? You want to increase that value and make more money for yourself and for your investors. The last thing that you need to do, and I'm not going to have time to talk about this completely, is talk to your patent attorney and have them explain a patent to you. Start on the first page, the cover page. It has a bunch of data on it. It's worth sitting down. And when I have new founders, I sit down with them. I say, okay, this is what we want to get. And I show them a patent and I say, we want to have this thing. And there's a front cover. There's something called a specification and some figures which describe lots of stuff, right? And then there's claims which describe a lot less than the specification. And the claims are what's covered by the patent. There can be discussion in the specification that has nothing to do with claims, right? That's old, right? People come to me and they say, look, somebody got this patent and it talks all about the stuff we've been doing for years. Oh, well, it doesn't matter. It's the 5 paragraphs on the 3rd page where their invention is in the context of all this other stuff that they actually are claiming, right? So you need to understand the difference between the specification and the claims and what rights the patent really gives you. Ask your patent attorney. Go through a patent with me, explain to me how the claims work. What does it mean to infringe a claim? What could make a claim invalid or valid, right? How do you read a claim and decide what it means? That's it. The last thing. This is a pet peeve of mine. To infringe a claim, you have to do everything that's mentioned in the claim. You have to, if it's a system claim, that it has a bunch of limitations. To infringe that, you have to have every limitation, right? Or if it's a method claim, it has a bunch of steps. You have to do every step. If you miss one limitation, you don't infringe that claim. You don't have to worry about it, okay? That means that a very long claim, like a column and a half in a patent, has so many limitations, it is virtually impossible to infringe, okay? It's worthless. And people come to me and they say, oh, I got this great patent, look at this, I want to start enforcing. And they flip to the back and there's this monster claim and it says, it has everything I do in there. Well, sorry. Somebody to infringe this claim would have to literally do everything here. What you want is a claim that's short, right? That's straight, small, has as few words as possible and straight to the point, okay? That's a really broad claim, right? In practice, you want both broad claims and narrow claims, right? With more limitations, but you have to, and a patent application has more than one claim just for that reason. There'll be some that are narrow and some that are broad, right? Shorter claims are broad claims. Big, long claims are nearly worthless. Great, that's it. I am now going to move. Oh wait, I have a slide. One more slide. Here we go. Okay. While I show this wonderful slide, this picture represents all the different cities where we have offices. There is about 45 of them around the world, and I'm associated with the Ramon's Tahoe office, and in beautiful Truckee, and associated with our Menlo Park office. And usually I'm, of course, in the Tahoe area, but I come to San Francisco quite often. So now I'm going to go first through the question and answer. And I see there was one, now there's two. I'm going to answer those questions and then I'll skim through the chat, see if there's anything that somebody asked me there. I know this question is probably there. Within a week, we will send a copy of the slides and a link to the recording of this presentation. So if there's any questions you had, you can go back and review it or share it with other people. My LinkedIn is on this slide. Please feel free to connect with me. I don't check messages there as often as I check my email, but usually at least once a week. And now I'm going to hit these questions. So looking over here, hold on. There is a question. Cheers, CHRS is asking, I'm based in Montreal and your law firm has an office there. Yes, we do. Does this mean it grants discounts to tech founders on your honorary fees? The fact that so I work with clients all over the world, even places where we don't have offices. Patent work, Zoom is fine. I like meeting people in person because, and I like working with early stage startups because I've been a CEO of 2 funded startups, both of which are still barely alive, right? So I like working with founders, and I spent most of the 90s as a CTO of a scientific instrument company. So I really like everything about startups, not just intellectual property. I do like meeting people in person, and I like helping people with things like with pitch decks and stuff like that. So I work with people everywhere. The fact that we have offices in Montreal, I don't believe we have any patent attorneys in Montreal, although we do have IP attorneys that work, for example, in the sports industry, right? So if you happen to be a star hockey player, we can help you there. But yeah, no, I have standard rates and they don't vary. Because Ramon is a semi-virtual law firm, our rates tend to be better than most big law firms. We are about 190 attorneys in total. And because we don't have this huge overhead of offices, we're also very, the average attorney at Ramon has well over 20 years of experience. It's a much more flexible situation than at the standard big law firm. So we have lots of people who spent many years at big law firms and then came to Ramon because it's an easier place to work and much more flexible. So you'll find that we have really competitive prices, fees, and really top quality. So for example, in my practice, I work with, of our roughly 20 patent attorneys, I work a lot with 2 or 3 other ones, and we all have over 20 years experience. I did my first patents in the early 90s, but that was as an inventor. And then I started working for a law firm in 2000. So that gives you an idea. All right, Mr. Anonymous. Anonymous is a famous, I heard a joke about Anonymous and I was going to use it today. It was something about a quote. Anyway, sorry. Anyway, Anonymous always comes to my talks, so welcome. Would you recommend a startup to invent on IP, considering that many times it makes competitor heads up and go around our patents in order to compete in the market? Okay, so I think I talked about that to the extent that the reason you're going to do patents is to increase the valuation. So assume that you want to sell your company or have, raise money from investors and so on. Those investors can invest, or that acquirer could buy your competition instead of you. And hopefully, if your patent attorney has done a good job, they have built a patent portfolio that makes you a much more attractive acquisition target, meaning you're going to get more money in your pocket. You can sit down with a patent attorney and talk about what things could be kept as trade secrets and what things should be kept as patents. And the trick to doing that is actually doing that process and then really setting up trade secrets. And you may decide to keep some things secret. I gave an example earlier of a coating that would be off patent by now, but it's still used all around the world in places you would never believe, right? So yeah, this is on a case-by-case basis. For companies that are taking investment, it would be very surprising not to have intellectual property filings and patent filings, right? Okay. Don is asking, where and how are trademarks and logos registered? Okay, so the patent in the United States, the US Patent and Trademark Office will register trademarks, and that can include a word mark, a word, or it can include some logo or some graphics, right? But that you can, the trademark attorneys at my firm will typically quote, $1,000 or $2,000, depends a lot on how many areas trademarks are divided by category. So a word could be a trademark for a woman's handbag and for a camera company, right? Because there's no likelihood that they'll be confused with each other. So you can, when you file your trademark, you might file it in more than one category. So that's what can cause the fees to vary, right? And also, you should probably, before you name the product, if you're planning on doing a trademark, you should at least talk to a trademark attorney to make sure that it's not too descriptive, or do a preliminary trademark search to make sure that nobody else has that as a registered trademark. You don't want to get 6 months into your marketing campaign and then get a letter from somebody saying stop, and so great. Okay, next question is from Al. Thank you for the great presentation. Question on legal ownership structure of IP. What do you recommend founders to consider for their IP portfolio? Typically, you'll want to assign the IP to some sort of legal entity, whether it's a partnership or a type of corporation. And your selection of what type of entity you create will depend on the location, the types of investors you're going to take, tax, lots and lots of tax questions, right? For example, here in the United States, a Chapter S corporation saves a lot in taxes, but it doesn't allow for more than one type of share. So you can't, VCs won't touch it. It doesn't allow, you have to have only US investors. There's all kinds of bells and strings that come with different entity formation. And you really need to sit down and do an analysis in your particular situation, decide what you want to do, right? And then there should be an agreement between the founders, or at least written into the initial founding documents of the company, that you guys are assigning your current inventions that relate to the project and any future inventions you have to that project, right? Okay, Edwin is asking, the question reads, new science work and equation for new technology, do I have IP? Okay, so what I'm understanding from your statement, Edwin, is that you have a new way of calculating something, and you're asking if that is going to be patentable subject matter. All right, do you have something that can become a patent? So there are things that can't be patented. Products of nature, right? Or straight out algorithms cannot be patented, right? So an example of a client comes to me and says, I've got a new way of doing business. I have a better way of calculating an option price or the risk on an investment. And I put in these numbers and I get this answer out. That is very likely to not be patentable, be hard to get, right? Because basically it's just mathematics. Right? You get around that once you start doing stuff with the math, right? So software, right? Every software program is an algorithm, right? But it does something other than just pop out a number. And let me give some examples of that can make something patentable. You sort data, you organize data, you analyze an image and come up with a word describing the image. You activate anti-lock brakes. These are all software things that are built, that they either are built into interesting hardware, okay, that has new features, or they do some new way of manipulating data or information, okay? And again, I do like 70 to 80% of this work that I do is software related. And so we do an awful lot of software. I have no issues with patenting software. It is rare. If the patent application is written really well, most of our software applications, the vast majority eventually turn into patents. So that's great. So if you have a new equation, to answer Edwin's question, right? You figured out a new way of calculating something. And there's plenty of cases like that, where somebody's figured a new way of calculating what temperature to melt a metal at in order to get some great result. It's not just the equation, it's the temperature sensor and the feedback circuit and all this other stuff. So it depends on how you're using the equation. What do you do with it? We'll patent the use. Okay. All right. Tom Dermody is asking me, can a common household implement with varying theme designs be copyrighted under one copyright application? Okay. You can copyright a whole series of stuff as a group, right? So if you have a series of paintings, or if you have a series of monkeys, pictures of monkeys, right? I'm thinking NFTs here, but okay, you can copyright a whole group of works at once. There's ways when you enter the copyright, when you do the filing, of getting coverage on different versions of something. Now, you're talking about design, and that might be the shape. We'll have to look close. You have to look closely. Is that going to be something for a design application, or is it going to be something for copyright? Okay? And that depends. Design application, you will probably have to have more than one application. All right. Okay, Edwin is asking me, he makes a statement saying the UK government has set up something at his work, Advanced Research and Invention Agency. I don't know what he's asking there. Sorry, Edwin. All right, so that answers the questions, and we still have a little bit of time. Yay. Okay, I'm quickly going to go through the chat over and bringing my other screen here. Okay, India, welcome from India. I hope you liked the different time. I try to give the seminars sometimes in my morning or midday or evening. Okay, so somebody is asking, do we have to pay every time the attorney has to argue or decline? Is that included in the initial fee? No, right? So there's a cost of preparing the initial application of attorney time, or whatever it is, whether it's provisional or non-provisional. You pay for attorney, if you're using an attorney, you'll pay for their time or on a fixed budget to get the application on file. And then it could be that it issues right away. It could be that you have 3 office actions, right? So that could mean you only are going to pay $1,000 because there's issue fees, right? Or it could mean you're going to pay $16,000 because you've got to file 3 extensive office actions. And we don't know what that's going to be. So yeah, that is an added cost, right? That you pay for it. The trick to working with attorneys is to ask for budgets, right? If you're an early stage startup, you don't have an unlimited, but you need, any attorney who works with startups should be initiating the conversation saying, let's talk about the budget. If they don't, switch attorneys, okay? Because that means in their mind, it's unlimited, right? You should, and if they don't, you should bring up the, if you don't switch, you should bring up a budget and say, this is the budget and exactly what it covers, all right, up to this point, right? So when I start with a startup, I'll say, okay, this is the budget for getting the application on file. And then we're gonna wait, 8 to 18 months to get a response from the patent office, right? And then there may be more. Okay, next, moving down. Okay, we had that question. Webinar, yes, we will within a week. It takes a little time, a few days for Zoom to have the link ready, but we will send out a link to everybody who registered for this. We'll send out a link and a copy of the slides. Tom says the slides he's seen aren't corresponding. Oh, it's probably just because I ramble all over the place. All right. Why would do some software tech? Okay, Mona is asking, why do some software tech advisors tell startups often you can't patent software, so just launch anyway? Well, they're wrong. I mean, literally, I do so many apps. I have an iPhone full of client apps. So let me give an example. One of the companies I was CEO of, I still am, it was a keyboard app. Right? It was a keyboard that you could download from the Apple Store and put on your iPhone. And it had a bunch of extra buttons on it. So you could actually, while you're in chat or an email, you could reach out and go, for instance, execute other programs like Dropbox or Yelp or something like that. And you could grab content from those programs and bring it into your chat. And it was really useful because you could do, if you're having a conversation with somebody or an email and you need a Dropbox link, it's right there in your keyboard. It was really cool. We have a whole bunch of patents all around that, stuff that's issued, and it will probably be someday enforced against people. So anyway, yeah, no, it's important. And investors who say otherwise, yeah, the provisional is really inexpensive. You should at least a good business strategy. Okay, so this is important, right? The chances of you succeeding are not great if you're a startup, right? So the business approach is to get, and I have 10 more minutes, right? Okay. The business approach is to file a provisional application, develop a mock-up of the software, go around and show it to people. Hey, does this work? Would you be interested in buying this, right? And then see if it has traction, see if investors will put money into it. And then, and only then do you spend the money for the later patent application, right? If you file a provisional and you work at it for a year trying to sell it and build a team and start a company and you don't get anywhere, right? You don't raise the money or the customers don't come, then you just say, okay, forget this. I've spent a year of my life on it. I'm not going to spend more years, right? The year of your life is a lot more valuable than the money, okay? Then you move on to a different project, right? And you've only spent, $2,500, $5,000 on some provisional applications. right? That's it. And you haven't sunk, tens of thousands into IP, and it's easy for you to switch, right? So that is a really good business strategy. I work with sometimes with a guy named Stephen Key, who runs an organization called InventRight for individual inventors. And he gives seminars that are very worth it on how individual inventors can come up with ideas, how to use provisionals to get initial coverage on it, and then see if you can sell the idea, right? Then they go around and I thought when I go to Staples or to Home Depot, I see products from that organization. They're real. It's a inventor-driven, inventor-run organization. I first met Stephen when he was a client, right? So there's a lot of IP shouldn't be looked at on its own. Sorry, it has to be looked at in connection with the business, right? And the trick is to find, you only spend the big money on stuff is going to be successful, right? The provisional lets you go and test the waters. Okay, all right. So Chris, oh, sorry, Chris. Okay, I figured out your name. Yes, yeah, there are several large, relatively large. We've been a virtual law firm for about 12 years. And it was a great place to be working during COVID because it was like, didn't affect us much. I traveled a lot less, but I'm doing more of it now, still being sort of pretty careful, but get vaccinated. And yeah, it's a big advantage to be, when I came here, I went and interviewed at a big law firm from Texas, right? And they wanted to charge $850 an hour for my work. And they said, oh yeah, but we have these clients, they insist that we write patent applications for 12 grand. And I'm like, well, wait, you can't charge $850 an hour and do a patent application for that amount. I mean, it doesn't work. And then he was like, well, for our favorite clients, we write off a good part of it. And it's kind of like, oh, this silly game, right? So big firms will have huge high prices, but they'll discount them. It's much nicer to not deal with that type of CRAP, right? So I charge substantially less and I do a better job. And the other big difference is I don't have a bunch of associates working for me. So if I am the person who is interviewing the inventors, I'm the one who's writing the patent application, right? And it's somebody with many years of experience, both in business and in IP. So that's something you won't get at big law firms. It's the people at the bottom of the huge pyramid that work there. Okay. Okay, next question. Is it wise to trademark every possible name for your product? No. You want really well, you don't want to also, your marketing, yeah, you don't want that. You want your product to be known by a really well-established name. And there should be a strong association between the name and the product. This is business, not law, right? You want if you make that strong connection, then you're not going to care so much about other things. If you're trying to prevent competitors from getting similar marks, yeah, maybe. But really, you want to have one product or service and one name, right? Without any confusion. You want everybody in the world to know you, right? By your product by that name. You might get domain names all over the place, of course, but that's a whole different subject. Okay. Okay, Tesla invented the first modern electric car. They have plenty of patents. This decade, every other automaker builds like having looked at Tesla. So they're asking about how come people are building cars that aren't infringing Tesla. They probably are, but they have IP of their own. So it's kind of, I think of it as a poker game, right? How many cards do you have in your hand? A company like Tesla is going to have a lot of IP, but some of it's going to be, and I know I know where they're being sued. I have clients that are in the battery space that are suing. Okay, and it's Panasonic that's getting sued actually. But yeah, the trick is to have your cards, as many cards in your hand so you can play with the big boys, right? So if you're going to be a new car company, electric car company, you should have an idea of what patents are out there. You need to develop your own set of patents so that when Tesla comes to you or somebody else comes to you and says, hey, you're infringing, you can turn around and say, well, I've got these and it looks like you're infringing those. So let's just talk, right? Sometimes they can't come to agreement. You have fights like Apple to Samsung, right? But yeah, it wouldn't surprise me if there was plenty of IP out there being infringed, but these companies are building portfolios mainly for defensive purposes, not necessarily to be offensive. Some companies are really aggressive, but not necessarily these. So we'll see. Okay, I got 3 minutes left. Somebody, Galvin says they make MVPs for startup founders. Good. Yep. Oh, what do I charge by the hour? Yes, I charge, what is it right now? $5.95. And it goes up a little bit every year. And if I'm writing patent applications, it takes me an hour per page to write a patent application. So I can budget, if you give me a firm budget, I will tell you exactly how many pages you're going to get. And I can charge by the page, including, double spaced, including figures, stuff. So that's it. You will, I use, and I got 1 minute left. I use the analogy of like buying a car. You can buy a Yugo for $6,000, $7,000, or you can buy a Jaguar, or you can buy a Camry, right? And there's a huge price variation. And it turns out that both the Jaguar and the Yugo are going to probably spend, well, Jaguar is now made by Tata, right? And so they're much improved, but it used to be that they would spend as much time in the shop as the Yugo, and the Camry was actually the best deal. Finding attorneys and hiring them is a lot like that. It's hard for you to analyze. Are you getting the best patent attorney? Are you getting somebody who, and I try to relate to, because I have a business background and I've been an inventor. Yesterday, my 36th patent issued, so I was happy. So yeah, we can do, get somebody who knows your space, okay? Don't hire a biotech patent attorney to do, and don't hire your divorce lawyer, right? That's not allowed, that's not possible. Find somebody who knows your space, right? They may have clients that are similar, but you either get somebody who knows your, I do patents pretty much, my background is a type of chemical engineering, electronics, and software, and optics. So I do pretty much everything under the sun other than pharma. And I have experienced the type of my scientific background is really huge, is broad. So I enjoy doing that. Some patent attorneys focus only on electrical and only on software. But it depends. Find somebody you like working with. And it's nice to have somebody like a firm like Ramon, where, I can connect, the people in Montreal, or do you need you have an issue in Warsaw, Poland, right? We can take care of that. That's it. Get somebody that you like working with and actually takes interest in your company. That's it. Good. Thanks very much. I enjoyed this, and keep an eye out. Well, we'll be doing a somewhat different webinar next month. And thank you very much, Rob. Again, I appreciate your hosting these. Everybody have a good day, and keep a lookout for the link. Thank you.